Hello friends, welcome to the discussion on the Arbitration and Conciliation Act 1996. This is part 5 of this discussion, and in this part we shall discuss section 16 to 22 of the Act related to jurisdiction of arbitral tribunal. Friends, this channel contains around 400 videos on more than 50 subjects. To find out all the videos, please go to the playlist of my channel. There you can find subject-wise playlist containing similar videos at one place. You may also join as a member of this channel for watching all videos before it is made public, and also to view all videos of the channel including practice set videos and mock test videos. Well, section 16 defines the competence of arbitral tribunal to rule on its jurisdiction. So every tribunal has its own jurisdiction. Its jurisdiction is defined. It cannot go beyond its jurisdiction. So the tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. So the tribunal can make any award or can make any ruling within on its own jurisdiction. It cannot go beyond it. And also the tribunal can make ruling whether an arbitration agreement existed or whether an arbitration agreement is valid. And for this purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of contract. So when the tribunal will decide on the existence of an agreement or the validity of an agreement, in such case, any arbitration clause that forms part of a contract shall be treated as an agreement. A decision by the tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Ipso jure means by operation of law. So when the tribunal will decide that the contract is null and void, it shall not entail that the arbitration clause is also invalid. A plea that the tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. So when a party will raise an issue that the tribunal has crossed its jurisdiction, he shall immediately raise the issue, but not later than the submission of statement of defense. Before submission of statement of defense, he shall raise the issue that the tribunal has crossed its jurisdiction or the tribunal has no jurisdiction to hear the case or make any ruling. However, a party shall not be precluded from raising such a plea merely because he has appointed or participated in the appointment of an arbitrator. So when a party has himself appointed an arbitrator or he has taken part in the appointment of arbitrator, till then the party can object on the jurisdiction of the arbitrator. It can make a complaint that the arbitrator has exceeded its jurisdiction or going beyond its jurisdiction. A plea that the tribunal is exceeding the scope of its authority shall be raised immediately when such event happens. So when any party feels that the tribunal has exceeded its scope, immediately he will raise the issue. But the tribunal shall admit a delayed plea on justified ground. So if there is delay in raising the issue and the tribunal is satisfied on the ground of the delay, then also he can admit the complaint or admit the plea. The tribunal shall decide on a plea where it takes a decision rejecting the plea and continues with arbitral proceeding and make a arbitral award. So when there is a plea against the jurisdiction of the tribunal and the tribunal has rejected the plea, then the tribunal will continue its proceeding and also give its award. But a party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award. So in such case, if the party is aggrieved, he can make an application to set aside the award of the arbitration. Section 17 provides for interim measures ordered by a tribunal. So a party can apply for any interim measure during the arbitral proceeding or after an award has been made but before it is enforced. So what is the timing when a party can apply? It can apply during the proceeding and also after an award has been made. But before the enforcement of the award, a party can apply. If the award has been made and the award has been enforced, a party cannot apply. Only before enforcement of any award, a party can apply. So what are the purpose for which party can apply? First purpose is for the appointment of a guardian for a minor or person of unsound mind for the purpose of arbitral proceedings. Second is for an interim measures of protection for the preservation, interim custody or sale of any goods which are the subject matter of the agreement. And third purpose is for the detention, preservation or inspection of any property or things which is the subject matter of the dispute in the arbitration. And next purpose is for authorizing any person to enter upon any land or building in the possession of any party, or also authorizing any samples to be taken or any observation to be made or any experiment to be tried. So for this purpose, a party can apply to the tribunal. And what is the timing? The timing is that it can apply during the proceeding or after any award has been made but before the award has been enforced. Section 18 provides that the parties shall be treated with equality and each party shall be given a full opportunity to present his case. So जो आर्बिट्रेशन में दो पार्टी जाएंगे दोनों को इक्वली ट्रीट किया जाएगा और दोनों को इक्वल एंड फुल अपॉर्चुनिटी दिया जाएगा कि वो अपने केस रख सके. And section 19 provides that the tribunal shall not be bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872. So जो ट्रिब्यूनल है वो कोड ऑफ सिविल प्रोसीजर 1908 या इंडियन एविडेंस एक्ट 1872 को मानने के लिए बाउंड नहीं है, जरूरी नहीं है उनको फॉलो करें. बट द पार्टीज आर फ्री टू एग्री ऑन द प्रोसीजर टू बी फॉलोड बाय ट्रिब्यूनल इन कंडक्टिंग इट्स प्रोसीडिंग. सो दोनों पार्टी वो एग्री कर सकते हैं व्हाट प्रोसीजर शुड बी फॉलोड बाय द ट्रिब्यूनल फॉर कंडक्टिंग इट्स प्रोसीडिंग. If the parties has not agreed to any procedure, the tribunal shall conduct the proceeding in manner it consider appropriate. So जब दोनों पार्टी कुछ एग्रीमेंट में नहीं पहुंच सकते हैं कि कैसा प्रोसीजर फॉलो किया जाएगा, तो ट्रिब्यूनल अपना जो फील करे एप्रोप्रिएट प्रोसीजर उसको फॉलो करेगा. The tribunal has power to determine the admissibility, relevance, materiality and weight of an evidence. So ट्रिब्यूनल अपने आप डिसाइड करेगा कि कौन सा एविडेंस एडमिसिबल है, कौन सा एविडेंस रिलेवेंस है, कौन सा एविडेंस मटेरियल है और वो एविडेंस का वेट का भी वो जज करेगा. सो ऑन दैट बेसिस ही विल डिसाइड टेक इनटू कंसीडरेशन द एविडेंस फॉर गिविंग एनी अवार्ड. Then section 20 provides that the parties are free to agree on the place of arbitration. In absence of any agreement, the place shall be determined by the tribunal having regard to the circumstance of the case and the convenience of the parties. So दोनों पार्टी डिसाइड करेंगे कहाँ पे arbitration का सुनवाई होगा, where the proceeding will be takes place. So they are free to decide. But if they cannot decide, then the tribunal will decide the place on the basis of circumstance of the case and also convenience of the parties. Then section 21 provides that the proceedings commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. So when it is stated that the proceeding has commenced, the date on which the request for the dispute to be referred to arbitration and it is received by the respondent, this date will tell that the arbitration proceeding has already commenced. Then section 22 provides the parties are free to agree upon the language or languages to be used in the proceeding. And in absence of an agreement, the tribunal shall determine the language to be used in the arbitral proceedings. So दोनों पार्टी वो डिसाइड करेंगे, एग्री करेंगे कौन सा लैंग्वेज में प्रोसीडिंग होगा। जब दोनों पार्टी कुछ डिसाइड नहीं कर सकते हैं, एग्री हो नहीं सकते हैं, तो आर्बिट्रल ट्रिब्यूनल डिटरमिन कि कौन सा लैंग्वेज यूज किया जाएगा प्रोसीडिंग्स में। वेल, लेट अस डिस्कस सम क्वेश्चंस। फर्स्ट क्वेश्चन इज whether the tribunal may give ruling on any objection with respect to the existence or validity of the arbitration agreement. Yes or no? Answer is yes. The tribunal has jurisdiction for give ruling on any objection with respect to the existence or validity of the agreement. Whether a decision by the tribunal that the contract is null and void shall entail ipso jure the invalidity of the arbitration clause? Yes or no? Answer is no. When a plea shall be raised that the tribunal does not have jurisdiction, तो कब प्ली रेज किया जाएगा कि जुरिस्डिक्शन है नहीं है आर्बिट्रेशन का कुछ मामले में? ऑप्शंस आर बिफोर सबमिशन ऑफ द स्टेटमेंट ऑफ डिफेंस और आफ्टर सबमिशन ऑफ द स्टेटमेंट ऑफ डिफेंस. आंसर इज बिफोर सबमिशन ऑफ द स्टेटमेंट ऑफ डिफेंस a plea shall be raised that the tribunal does not have jurisdiction. When a party cannot apply the tribunal for the appointment of a guardian for a minor. So कब a party apply नहीं कर सकता है ट्रिब्यूनल को for appointment of a guardian for a minor? Options are during the proceeding or after the award but after it is enforced. C. After the award but before it is enforced. So कब वो अप्लाई नहीं कर सकता है? Answer is after an award and after it is enforced. So जब अवार्ड हो गया हो और उनको एनफोर्स भी किया गया हो, so उनके बाद पार्टी और कोई अप्लाई नहीं कर सकता है फॉर अपॉइंटमेंट ऑफ गार्डियन ऑफ ए माइनर, बट बिफोर इट इज एनफोर्स्ड वो अप्लाई कर सकता है. द ट्रिब्यूनल शैल नॉट बी बाउंड बाय व्हिच ऑफ द फॉलोइंग एक्ट. कौन सा एक्ट को ट्रिब्यूनल मानने के लिए जरूरी नहीं है? कोड ऑफ सिविल प्रोसीजर 1908, इंडियन एविडेंस एक्ट 1872 और बोथ ऑफ दिस. आंसर इज both of these. In absence of an agreement between the parties, the place of the arbitration shall be decided by the tribunal considering which of the following facts. So जब दोनों पार्टी कोई प्लेस ऑफ प्रोसीडिंग में एग्री नहीं कर सकते हैं, तो ट्रिब्यूनल वो प्लेस को डिसाइड करेगा. So जब डिसाइड करेगा वो कौन सा फैक्ट को कंसीडर करेगा? फर्स्ट इज सर्कमस्टेंसेस ऑफ द केस और convenience of the parties or both of these. Answer is both of these. Which of the following is to be considered as first preference for the language of the tribunal? So जब ट्रिब्यूनल का लैंग्वेज डिसाइड किया जाएगा, किसी को फर्स्ट प्रेफरेंस दिया जाएगा? ऑप्शन सर इंग्लिश और द लैंग्वेज एज एग्रीड बाय द पार्टीज और द लैंग्वेज एज डिसाइडेड बाय द ट्रिब्यूनल. Answer is the language as agreed by the parties. Thank you. You may join as a member of this channel to avail benefits like watching all videos before it is made public and also to view all videos of the channel including practice set videos and mock test videos. Thank you again.